Not a whiz kid. I'm going to start by saying a sincere thank you to each of you for coming along today. I value your time as much as you do, and it's a privilege for me to be able to share my ideas with you today. So I'd like to start with a thank you. For those of you who don't know me, I'm a solicitor. I'm 23 years a solicitor. I'm still learning. I'm 5 years an accredited mediator and still learning. And I'm 14 years a fellow of the Institute. And the whole concept of learning is important to me. And the reason I say it is because for me, learning is sharing. And what I want to do today is simply share with you some of my ideas in relation to mediation, and in particular, court alternative mediation. I'm going to try and provoke you to start and say, why is it that mediation is not being used in our legal disputes? Why is it not being used in our court proceedings? My experience is that it's succeeding reasonably well in the commercial court, but it has no real foothold yet in the other courts. And I think that's something that we should look at, and something that we can certainly change for the better. I was looking around and I read a lot around this particular topic, and one of the quotes that I liked was from Lord Clark, former Master of the Rolls in England and Wales. And he had an explanation. What he said is the reason why mediation is not used as much as it might be, if it is not, is lack of education. What is required is education of judges, lawyers, both solicitors and barristers, and perhaps most important, repeat clients such as liability underwriters. Put another way, education, education, education. My experience of mediation, and I have a lot of experience to gain yet, is that mediation is evolving. It's changing. There are now many different types of mediation. You can see the list there, and it's growing all the time. I'm going to add to that list now and say there's debt mediation, and shortly there's going to be planning and environmental mediation. And the reason that mediation is evolving is to effectively address the needs of the parties. When parties have a dispute, they can have different needs, they come from different backgrounds. And by looking at where they're coming from, a process of mediation can be designed to fit their needs. And if you take that as the starting point, and then go and look at the court system, and you go to legal disputes and you say, well, how can we design a model of mediation that will work for legal disputes and that will work for court proceedings? We're blessed by having some great minds in the Institute, and we've been having, I say this humorously, good rounds in relation to how to progress this. And there are different views, but two key aspects came out. And the first aspect was, if it's going to work, if it's going to succeed, you need to include the solicitors and barristers in the mediation process. And the other important aspect was the need to accommodate legal requirements and procedures. And in order to accommodate legal requirements and procedures, it's important that the mediators know about requirements and procedures in the courts. For us, this meant training. The mediation, the draft mediation bill, which is on the way, at head 13 includes reference to the mediator making a report to the court. And this is all new and requires training down the road. One of the humorous comments that I heard along the way was, leave the solicitors out, leave the barristers out, they'll only create trouble. It'll work better as a system if you leave them out. And one of our group said to that, well, I don't want to be part of any mediation process that excludes me as a barrister. And he's right. If you're going to have people be part of this system, there has to be inclusion. In terms of a lot of work has been done in terms of background with the Law Reform Commission. And what they were saying is that the parties should have access to the procedure of mediation without being obliged to use a legal representative. That said, the parties should not be prevented from being represented or assisted by a third party. So it's not available to the mediator to say, no solicitors, no barristers. In order to progress the whole concept of court alternative mediation, the message has to go out, lawyers, welcome here. The benefit of having a solicitor or barrister at a mediation is that as the mediation proceeds, they can give their client legal advice, and then, assuming a successful mediation, they can assist with the drafting of the mediation agreement. It comes back to education though. A solicitor or barrister coming into a mediation who doesn't understand mediation can kill the process. And the last person you want in a mediation is somebody who has their own agenda. So it goes back to the process of education. Now, what I'm glad to say is happening is that more and more solicitors and barristers are being educated in relation to mediation. And there's a change of attitude happening. At the moment, the Law Society, for example, are running a course, a diploma in mediation, which is engaging with solicitors, experienced solicitors and barristers. And that, to me, is the way forward. Where we're at the moment, in terms of mediation, the mediation bill, just to give you an update, 2 weeks ago, in the Dáil, Minister Shatter said that the position is that I intend to bring forward a mediation bill next year. And what he's saying is important, because he wanted to include in a short sentence, or a couple of sentences, what it's all about. And what he was saying is he wants to promote mediation as a viable, effective and efficient alternative to court proceedings, thereby reducing legal costs and speeding up the resolution of disputes. The bill, which is currently being drafted, will introduce an obligation on solicitors and barristers to advise any person wishing to commence court proceedings to consider mediation as a means of resolving a dispute before embarking on such proceedings. He also pointedly said it will also provide that a court may, following the commencement of any such proceedings, on its own initiative, invite parties to consider the mediation option and suspend the proceedings to facilitate such a process. He also said something which I sensed was new, that wasn't in the draft mediation bill. And he said, I'm at present giving consideration to the possible inclusion of an overarching governance structure for the mediation sector in the future legislation. I interpret that to mean governance, regulation, and a register of mediators. My own view on that is that it's a good thing, because what's very important is credibility. He also said in relation to that structure, as it were, that such a representative structure could, for example, play an important role in the promotion of mediation as an alternative to court proceedings and in the development of codes of practice for the sector. Again, I think this is important. It goes back to the education. For those of you who are familiar with the draft mediation bill, a critical part of it is the education. And the structure that's envisaged is that it will fall to solicitors and barristers to educate their clients. Head 4 of the draft bill is going to put a duty on solicitors to effectively teach or educate their clients about mediation and advise that mediation be considered, to provide information on the mediation and mediation services, to give an estimate of legal costs involved in terms of going to court, which in my experience is always frightening, and will also place an obligation on solicitors to give an estimate of the duration of court proceedings. And importantly, there will then be an obligation on the solicitor to get the client to sign a statement witnessed by the solicitor saying that they have received this advice. That's a pivot piece in it. So looking towards the future, my own estimate is that the mediation bill will be published early in the new year, and that it will become law by this time next year. I'm fully expecting that it will be on the statute books. When that happens, there's going to be a far, far greater need for mediation and practitioners, mediators, who will be able to assist in the resolution of legal disputes and court proceedings. So, what is the Institute doing? Jim mentioned that we had a strategy day this time last year, and arising out of that strategy day, a number of ideas were discussed, and more than a few have been implemented. I'm glad to say that one of the ideas that's taking shape was the whole concept of court alternative mediation, which began life with the name litigation mediation. But a number of us felt that that was a little bit obstructive in terms of the name. It didn't quite fully describe what was happening. A special interest group was formed, and I see many of you here, you're on the special interest group, and a sincere thank you to each of you. And when you're formulating a type of mediation to fit the needs of the parties, the focus has got to be what is the type of the dispute and what are the needs. We've been doing that. Another focus has got to be developing core knowledge and skills. We've been doing that. And then coming back to the education, it's essential that there's training. We're doing that. We had our first training day on the 5th of November, which was a very successful day. There was great feedback. And the next part of the training is to arrange workshops. There'll be a number of workshops between mediators who are interested in progressing the concept of court alternative mediation, which will act as a learning and sharing workshop. At the moment, we're in the process of forming a panel. This will be the list of go-to people if you have a legal dispute. And the plan will be effectively to get that panel out into the hands of every solicitor and barrister in the country, so that we hit the ground effectively running. We're talking about purpose-built mediation. As Jim was saying, the mediators on this panel are already trained and accredited mediators. But this, if you like, is an extra skill in their toolbox. Part of the whole purpose will be to inform and assist relevant sectors in terms of understanding court alternative mediation. And in that regard, I'm particularly grateful to you, Brendan, for coming along today. It'll also include distribution of a brochure on your seats. I think you've got a brochure. I'd ask you to take that away with you today. Another important part of the work that we'll be doing is to support the panel mediators and users of this service. No idea comes from just one mind. I just want to say a brief thank you to all the people involved. I'm not going to call out all the names, but you can see we have a good team, and we're playing the 3-3-3-1 formation. Finally, what I'd say to you, if you're not already a member of CIARB, please join. We'd love to see you. Thank you.